Hi, I'm John Counsel. I'm a senior reporter with Texas Lawyer newspaper, and welcome to the January 30th, 2009 edition of Reversed and Remanded. My guest today is Ralph C. Red Dog Jones. He is a partner in Dallas's Jones & Geisler, and he's a very well-known, well-respected plaintiff lawyer here in Dallas. And Red Dog, the story that I have in this week's paper has to do with an issue that I believe you're very familiar with. It's the expert reports that are required in medical malpractice cases. The Supreme Court has been struggling with these reports, what constitutes reports, what you have to have in them, and in their most recent opinion on this issue, they have decided that if a plaintiff files a deficient report, the courts are not going to allow mandamus review. Now, as I understand it, HB4, which created this mechanism, says that you can have interlocutory appeal review of instances where there's no report filed, but you can't have it if the report is merely deficient. And now the court has said you can't attack these collaterally with mandamus review if the report is deficient. And you know, I guess is that the right way to go? I mean, is that obviously? I mean, like the plaintiffs win on this one, so I would imagine you think that's a good opinion.
Well, the plaintiff won for a while, and part of it is that the first report was deficient. A second report apparently was filed, and there was no either complaint on that second report except for a direct appeal to the Texas Supreme Court.
And a mandamus.
Well, yeah, two and one.
Right, 2 and 1, and then they appeal, I guess, mandamus to the Supreme Court.
Right. And then the Supreme Court says, no, he can go back and address it with a trial court, so at least the plaintiff gets another bite at the apple.
Right.
So that's where it sits now.
Right, and I think the interesting thing about this opinion, and the reason I wrote about it, is there's a lot of disagreement on the court about what constitutes a report in the first place. You have concurrences on this court that say, look, in this case, the report was so deficient, it wasn't a report at all. In Red Dog, in trial courts, are we seeing a bunch of battles on that very issue?
Well, it's generally a battle on any time that you have an expert report required as to whether or not it addresses what has to be addressed and whether it's sufficient in what it addresses. And the trial judges are put in the position of being a gatekeeper and trying to decide whether the report is adequate or not. And then from there, you can end up with a mandamus or an interlocutory appeal, depending on what the report is.
Why do you think we're seeing this fight over and over and over again in trial courts?
Well, you're seeing the fight there because, one, you can bill for it if you're on the defense side,
yeah.
And two, you can win for your client if you're on the defense side,
right,
and have the case thrown out pretty much in the beginning. And then there are other issues too. I mean, it's 120 days from when you file suit.
Right.
So if you don't have the defendant served until the 115th day, guess what? You got 5 days to file a report.
Yeah, and that's trouble. Yeah.
That can be very troubling. But the report has to address some of the basic tenets of what's required in House Bill 4,
right,
Chapter 174, or Chapter 74, and that is that you have to, one, give your qualifications as an expert, two, set forth what the standard of care is, three, what the breach of that standard of care is, and four, the causation issue of whatever that breach being the cause of the damage, injury, and harm. So that's what we're dealing with, and if the report doesn't address those basics, you have no report at all, and that's what Watkins was all about. Some of the justices, I think 7 of 9, contributed to this opinion,
yeah,
and some of them said it wasn't a report at all.
Yeah, yeah. All right, another interesting case that was filed recently in Dallas County Family Court is one that I think is going to have some interesting constitutional ramifications, and that is a petition that was filed on behalf of a legally married same-sex couple. They were married in Massachusetts, I believe. They moved to Dallas many months ago, established residency, I believe, and have problems and want a divorce like everybody else. Now, the Attorney General's office has intervened in this case, saying that they shouldn't be able to avail themselves of the court because our state does not recognize same-sex marriages. Now, Red Dog, I know family law is not your issue, but I'm sure you're pretty familiar with the Constitution, and I'm wondering if you think this thing has legs if it ever went to a federal court and we had to match up our state law, which prohibits same-sex unions and our recognizing of them, and the U.S. Constitution, which says that we have to recognize other states' laws. Who do you think is going to win this one?
Well, interesting concept. Federal courts will have a chance to rule on this most likely, but it goes back to the basic issue in Texas family law, and I did some of that years ago.
Yeah.
The law has always been in Texas a marriage was between a man and a woman.
Right.
Now with some states allowing man and man or woman to marry, the issue becomes, can you get a divorce in some other state? And the states have to give full faith and credit to other states' laws. And so you're going to have a real interesting constitutional issue here that the federal courts will probably have to address. But this poor couple, I mean, they want to separate, they want to get a divorce. I do take a little issue with everybody wants a divorce, which
right.
you said, not everybody, but
yeah.
If you want a divorce and you have had a same-sex marriage, Texas is one right now, probably not the place to go. But two, it also brings up an adage that I've always had, and that is, I'm sorry to say this, but 100% of divorces are caused by marriage.
Exactly. All right. Red Dog, it's now time to put you in what I like to call the witness stand. I'm going to ask him some absurd questions and see what Red Dog has to say. All right, first question. Red Dog, since the legislature has capped damages in med-mal cases, doesn't it make sense that they should also cap damages in legal malpractice cases too?
Well, you wonder how our lobbyists let us down there. If you can cap one area, why can't you cap another area? But it goes back to the basic issue of caps are wrong for anyone. And yes, I'd like caps on anything I do that's egregious, but it's wrong.
All right, thanks. Okay, second one. Same topic, sort of. Lawmakers have banned gay marriage. Shouldn't they just go ahead and ban marriage for everybody?
Well, like we said, 100% of marriages are cause divorces. I don't know that we could do anything with the concept of marriage and divorces. I know the legislature is trying to make it harder and harder to get a divorce, so they're making people stick together. The economy is going to make people stick together, so it'll be interesting to see what happens.
All right, final one. Red Dog, how are you personally welcoming home former President Bush?
I will be cordial, I will be diplomatic, I will be polite if we run into each other at a grocery store.
Red Dog Jones, ever the gentleman. Thanks for coming on.